You've got third-party submissions. You've got supplemental examinations. There is no other country that does a supplemental examination, and I think few are looking at it. You've got priority examination for important technologies. You've got inter-parties review. That's the biggest change, in my opinion. There is no longer, as of that date, inter-parties re-examination. It has been converted to inter-parties review. There is now a new process called post-grant review, and that's something that also happened on that date. And there's a transitional post-grant review program for covered business method patents. I disagree with that provision. I did not support it. It was inserted by the financial service industries through Senator Schumer, and I am glad it's transitional, and I wish it was more transitional than it currently is. But those are the important ones. Then we get to March 16th, 2013, which is still to come. And you'll see the bottom one, statutory invention repeal. That's nothing. I hadn't seen one in 20 years working there. Derivative proceedings, I don't think you're going to find many of them. In fact, the Patent Office has budgeted them at $400 per proceeding, and that's telling me they don't think there's going to be many of them, or they'd be charging a lot more. The big one in that area is first to file, and I've got to admit to you people in the room, it is not a true first to file system. I'll talk more about it. I am not pleased with the way the negotiations went, but it is not a first to file system purely. It is a first to disclose or file. So that's an important deal. Transitional business method for covered business method. This is if you've got something in your invention that doesn't have what the Europeans would refer to as the technical aspect. So it's a pure business method. The idea is you can challenge that. Now you can only challenge it if you're already in court, but you can attempt to invalidate it. You may invalidate it based upon any grounds, and it goes through a process very similar to post-grant review. So there is a procedure set up that moves that very quickly. There have been some filed already, not many, and I don't expect many more will be filed. I think the initial ones are the important one. Why I disagree with this is to remove business methods. So it's singling out a particular area of patent subject matter. And in fact, the ability to examine in that area has improved dramatically over the years. I do believe a lot of very improvidently granted patents were issued. They become prior art, and over time, when the examiners get more experience and the databases get more complete, things meet a stasis level, and I think that it is unnecessary to undertake this new procedure. But the financial industry, which was not familiar with filing patents until State Street Bank, and they were always patentable subject matter in the United States, but State Street, the case, actually provided information that made everyone aware of this type of patent. The financial industry was not happy with the system, and in fact, when it was first flooded with applications, a lot of bad patents were issued. So there was a problem there, but I think it was cured over time. Supplemental examination, brand new procedure in the Patent and Trademark Office. It allows you to fix your U.S. patent after it's issued. And what is really interesting about this is you can bring any issue to the office to try to fix it. Now, you can't introduce new matter into your patent application, but you are capable of fixing more than 112, which is our obviousness or written description requirements, more than enablement, more than any prior art issue. Any type of error you can bring to the Patent and Trademark Office. This still goes through a process much like a reexamination, an ex parte reexamination. It will conclude within 12 months of initiation, so it is fairly quick. It is expensive, a minimum, I think, of $22,000 US, so you better be really interested in making sure you're clearing it. If you conclude the process prior to institution of a lawsuit, you will be absolved of any inequitable conduct, which is another really important thing. So when would you use this? I think you want to use this before you're going to start licensing your patent, if there's any cloud over it, or if you're going to be purchasing patents from someone else and you want them to make sure that everything's cleaned up. And those are the two circumstances where I would say this is something you want to do. Otherwise, I think it would be too expensive. You can always go ex parte for prior art issues, and I would recommend that as a way of going forward if you really are not too worried about the timing, because this is very quick, and don't want to pay for the money. So I think I've said enough about that. I do know other countries are looking at this. So third-party submissions of prior art are now more extensive. We always had prior art submissions in the United States. I know they have them in Europe. I think 6% of the applications in Europe receive that type of submission. I think this is really interesting if it's not in your core business. If you've got a patent application that you know about that's out there and you want to kind of get rid of it very quietly and very easily, you can supply up to 3 references. You do not have to pay any fee. You can talk about the relevancy of those references to the claims as they're published, and you can remove them. Now, why I would not do this in core business areas is because I would want to be engaged in the back and forth between the examiner and the applicant to explain my position more. And that's why I probably would not be doing this in a core area. But I think it is really a good move in a nuisance type area to knock out an application fairly inexpensively. Derivation proceedings, as I said, are basically you stole the application, and it's not your application. The Patent and Trademark Office has actually determined that they expect to receive 10 of those a year. I don't think I would be focusing too heavily on these. I don't think you're going to see very many of them. But I think it's a good thing to have it provided for because it's a way to get rid of somebody who's actually taking the invention that's not theirs. This is the big one, in my personal opinion. Inter-parties review proceedings. Now, you're going to see some changes in standards in the United States. In this one, it's reasonable likelihood that the requester would prevail. In a post-grant review, you're going to see more likely than not. My personal opinion is that neither of those standards are very important. If the examiner thinks they've got a rejection, they're going to make it. So that's what's going to happen in both post-grant and inter-parties review. This allows for, this can only occur 9 months after issuance. Post-grant's going to come before that. It is only limited to written prior art or patents, so that you are knocking out applications with respect to written prior arts or patents. It moves very quickly. It's again handled within 1 year after the enactment, 1 year after a decision has been made that is granted, and it is going to be a very interesting and quick procedure for a third party to challenge a patent inexpensively without going to court. These are going to be much cheaper than litigation in the United States. There are already about 120 of them filed. They've got teams of Board of Appeals judges. They hired in excess of 200, I think, to be able to handle them. I think this is a good way of going, particularly if you're confident of your rejection. I'll explain that a little bit more later. Post-grant review is the first 9 months after issuance. So it's a different type of review. It's broader, though. It's not limited to publications or written prior art. It also allows for written description, enablement, so you can challenge on any statutory basis in post-grant review. Now, you've got to get your act together very quickly because, as I said, this is in the first 9 months. And the estoppels in both of these procedures are extremely important. It's raised or reasonably could have raised in both of them. So you better have all of your statutory requirements down. Your case has to be fairly significant and built up, anticipating what other type of problems you may want to face later on and if you're bringing these cases, because you will be barred from bringing a case in a court later on or another procedure in the Patent and Trademark Office if you raised or reasonably could have raised the issue in the procedure you brought it. So you need to make some considerations in the PTO. And attorneys in Washington, we've been discussing this for years now. Courts or the PTO? Do you go to court? Do you go to the USPTO? Well, there's lots of issues deciding that. Courts, you've got probably a little broader discovery going on in the United States. It's going to take longer in the United States. It's going to be significantly much more expensive. I see estimates of $5 million is not uncommon. Significantly less than that in the PTO. I'm hearing $350,000 to $500,000. You really need, your standards are different. Your claim construction standard is broader in the Patent and Trademark Office than it is in court. However, your idea of the patent is more challengeable in the Patent Office. That's more important. You are before experts in the PTO. So if you've got a very strong prior art reference, you actually want to bring it in the PTO. A weaker case, don't tell my judge friends, but maybe bring it to district court because you may win when maybe you shouldn't. So I think there's a lot of considerations, a lot of strategies. Costs are another thing. Much more expensive, as I said, in courts, much cheaper at the Patent and Trademark Office. Timing, much, much quicker at the PTO. Statutorily required to conclude in 1 year from initiation with limited extensions of 6 months in special cases. So those are very important issues. Now, I told you post-grant review and inter-parties have different standards. That shouldn't affect anything. But you see you can bring non-written prior art rejections, and you can only bring written prior art in inter-parties review. So there are some other strategies you need to start thinking about. If you have a really strong reference, when should you bring it? You really shouldn't bring it in post-grant review. Why? Because if you brought it in post-grant review, you are stopped from bringing anything under 101, 112, and 101 is enablement, and 112 is written description, 101 is patent eligibility, 112 is written description or enablement. Those are not something you can bring in inter-parties. So you could bring your prior art reference under inter-parties review by simply waiting not 9 months until you're able to do so, and you would still have 112 and 101 available in court later if you in fact lost. So there are some strategies being developed around the world with respect to how to practice these. Timing. Inter-parties review is now available for cases that issued pre-1999 November. So if your clients are paying maintenance fees on important cases still, those are challengeable, and we're seeing some of them. I don't think you're going to see post-grant review in any significant way, with the caveat except for those transitional business methods, because post-grant review is only available for cases that issue under our first-to-file system. And our first-to-file system doesn't start until March 16th of this year. So it has to issue. I think you're not going to see them until probably a large number of them, 2016. But it's something to start thinking about. Supplemental examination, I kind of told you what you needed to do. You make the request, the PTO decides within 3 months, and then they move forward with basically an ex parte re-examination in our senior examination areas. The other types of cases, the inter-parties review and the post-grant review, go directly to our Board of Appeals. They are not handled by examiners. So you've got much more expert people handling those types of things. First inventor to file. I don't really know what to tell you about this. I'm telling my friends, never, ever, ever, ever publish without filing a provisional application in the United States Patent and Trademark Office. And that's for many, many reasons. But I think the way we put together our first to file, it is so that university professors who do like to publish, they have a saying in the United States, publish or perish, if they errantly publish their invention prior to filing the provisional application, we will forgive them in the United States and allow them still to get rights in the United States. But recognize they've lost their rights almost everywhere else. And with the strangeness of the terms and the fact that they're losing rights overseas, which I think is a bad thing, I do not recommend doing any discussion or publication prior to filing an enabled application as a provisional, doesn't have to be, I'd usually have a claim in it, but you don't have to, in the Patent and Trademark Office. So again, I do not want anyone to think that they should be able to just talk about things freely and still can get rights in the United States. You can, but it's not a good idea. So I'm not going to spend a lot of time on this. But let me mention some other changes that may be important here. There is now a public use or sale anywhere in the world. So public use and sale in India can now bar an application in the United States. And that's a change in the law in the United States. But look at some of this new language in here, and you can see I highlighted it for you. It says, public use, on sale, or otherwise available to the public. Well, does that modify the on sale? Does it have to be a public sale? What about a private sale? There are many issues in this entire section that will have to go to the courts to be determined. And I think you're going to see litigation in all of these areas very soon, but I don't think we're going to have determinations very soon. So we're all going to be operating a little bit in the dark. The Helmer Doctrine is gone. We've got another confusing issue with respect to deemed publish, an application designating the United States filed in Korean in the Korean office is deemed published. So I think you're going to see issues related to that. You've got disclosures, as I mentioned to you, disclosures made in the United States 1 year prior to your filing are absolved, so you're able to still get a patent in the United States. Patent disclosures, no time limits to them at all. Let me give you an example so you can see how unusual our system is. In January, A files. In April, B discloses. In July, B files. And in October, A files. Who, if anyone, gets a patent? Under our new statement, A gets the patent. Now go back and look. A discloses, so his disclosure is graced, meaning he can still get, even though he files after B, and B has already disclosed, that is a graced disclosure, it's within the 1 year period, A gets the patent. So it's not a true first to file, and I just wanted you to be clear about that. Now I want to spend a little bit of time about talking about issues to the patent and trademark offices of the world. One thing that I see developing, I've been engaged in the patent business for over 30 years, and I hate to admit that, but that's a long time. We talk about harmonization, and I really think it's a very laudable and important goal, but I don't see harmonization in a true form coming to the world anytime very soon. However, I do see cooperation between the different countries and between their offices, which may eventually lead to a better harmonization. I think that one of the ways we're doing this is through work sharing. I don't know if people are aware of the Patent Prosecution Highway, but it is a brilliant move invented by the Japanese, where an application is filed in 2 districts, for example. The Office of First Filing does a search and examination, and upon indication of allowable subject matter, the application is modified in the second office to comport to that allowable subject matter, and that second application is accelerated through the system. So it's a way of moving things forward in a quicker manner, and I'm seeing a very effective mechanisms for handling this. Look at the percentage allowance rates. They're huge compared to regular applications. And let me tell you something else I'm noticing. I'm not seeing a lot of continuing applications, which tells me that people are happy with the scope of the claim they're getting. So this is one way we can all start working together to understand how we're working and to use the results a little bit, which isn't true harmonization, but it's sure a step in the right direction as far as I can see. One other new aspect in the PTO that I know other people are looking at, other countries, is Track 1 prioritized examination. And what's interesting about this, it's not cheap and it's not for all of your patent applications. But you have something you need to know right away. You need to know quickly whether or not the United States is going to issue a patent there. For a fee, we are the United States, for a fee, we will accelerate your application through the system. All you have to do is pay $4,800, and there are no special averments, there are no special searching, you don't have to do anything else. You will get a final action or an allowance within 1 year. And that is the obligation of the PTO. Now, they say you're limited to 4 independent claims and 30 total claims, and that's true, but let me tell you, you want more claims? While it's pending, file a continuing application, and you can let that one languish for a while. But you will be able to get the claim scope you need. You will get an accelerated application. I think this is a very effective mechanism for getting a determination out of the USPTO quickly. It can also serve as the basis for a PPH application, moving you more quickly through the system. Here are the stats on prioritized examination as of about 6 months ago. They're very quick. All of these, both the PPH and the